A trial is held in a courtroom which is open to the public. The prosecution's witnesses and your witnesses must remain outside the courtroom until they have given evidence. Thus, you must inform your witnesses to remain outside the courtroom. At trial, the prosecution must present evidence to prove your guilt beyond reasonable doubt. Note that any time during the trial, you are allowed to change your plea to guilty. The trial procedure is usually as follows. The trial begins with the prosecution calling their witnesses to state what they know about the alleged offense. This stage is known as examination in chief. Documents, pictures, and other objects may also be presented as evidence through the witnesses. You should listen carefully to the questions and answers and make notes for your own reference. After the prosecutor has asked all the questions of each witness, you will be allowed to question the witness. This is called cross-examination. The purpose of cross-examination is to ask questions to show that the evidence that the witness has given is not safe for the court to rely on. You should also ask questions which may elicit answers helpful to your case. You must give your version of the events to the witness and ask the witness if he or she agrees with it. You are not allowed to ask questions that are intended to insult or embarrass the witness. Next, the prosecutor may ask questions to clarify the witness's answers in cross-examination. This is called re-examination. After the prosecution has closed its case by calling all its witnesses, you may then make a submission of no case to answer. This is an argument that the evidence presented by the prosecution is not enough to make out a case. If this submission is accepted by the court, you will be acquitted at this stage. If the court finds that there is enough evidence to proceed with the case, you have two options. You can opt to give evidence from the witness stand or to remain silent. If you choose to remain silent, it may have a bad effect on your case. The court may take this into account when deciding whether you are guilty or not. You can call other witnesses to give evidence in support of your case if you have elected to give evidence or remain silent. If you choose to give evidence, you will have to give evidence before your other witnesses. After taking the affirmation or oath, you should introduce your name and address, followed by your current occupation. Thereafter, you can proceed to give your version of the events. The prosecutor will thereafter cross-examine you. After cross-examination, you can further clarify your evidence in re-examination. When you have finished giving your evidence, you may then call your other witnesses. As these are your witnesses, you will be given the opportunity to ask them questions first, before the prosecutor cross-examines them. Similarly, you will be able to re-examine your witnesses after the prosecutor's cross-examination. Please note that the questions you ask your own witness should be open-ended questions instead of stating your version of the events and asking the witness if he agrees with it. After you have presented all the witnesses for your case, the prosecution may in some cases make an application to call a rebuttal witness or witnesses. A rebuttal witness is allowed to be called only to rebut new information introduced by the defense. You can also cross-examine a rebuttal witness. After all the evidence has been presented, both you and the prosecutor will be asked to make your closing submissions. These are speeches summarizing the evidence and arguments to persuade the judge to decide the case in their favor. You will be asked to make your closing submissions first, followed by the prosecution.